Another critical piece of information which I didn't mention before is what's referred to as the financial performance representations, FPRs. That's contained in item 19 of the franchise disclosure document. This is a place where the franchisor, if it wants to, can make a statement about the revenue, profitability, earnings capacity of a franchise, of historic franchisees or for the franchisees in the future. Franchisors are not required to provide FPRs, and most don't, particularly startups. I think the statistics are that 70% of franchisors don't provide financial performance representations. It can be a minefield for litigation, and people tend to avoid it, but many systems do provide that information, and it should be reviewed very, very carefully and analyzed to see if you're a franchisee or prospective franchisee representative, to see how the franchisor made a determination of the FPRs and what that means for your client on an ongoing basis. Most franchisors don't do it, but if they do, they need to be very, very careful in how they outline the information. Not only is information required to be put in a franchise disclosure document if you do it in item 19, but it has to be, the method by which the franchisor calculated the information that's contained in the financial performance representations has to be stated. Many franchisors, for example, give a list of, or give an average revenue of franchisees open for a specific period of time, let's say. They should indicate whether, how many fall below the average, how many fall above the average, for example. They should indicate that the franchise or franchisees that they're referring to in item 19 are those that have been open a year or 2 years or whatever the calculation is based on. But it's critical to state it in substantial detail. It will be scrutinized by prospective franchisees, and again, as I indicated, it can be the subject of problems later in litigation issues. And so it's very, very important to make sure that it's done in the most accurate way possible, and that whatever caveats exist are stated in substantial detail and in a way that franchisee could not later indicate that there was some improper information or misrepresentation in that information. What's critical to tell your franchisor clients is that franchisors are not allowed to provide any financial performance representations at all unless they're contained in the franchise disclosure document in item 19. And they're not allowed to provide information that's different than what's in item 19. And many franchisors make the mistake of telling franchisees, for example, that they'll break even in 90 days, or they'll be profitable in the first year, or that they'll make $1 million, or whatever it is. And you have to be extremely careful when you are selling franchises, recommending to your franchisor clients, and make sure they know what they can and can't do. And what they really can't do is provide earnings information, financial performance representations to prospective franchisees without including the information in the FDD. The other side of that coin, of course, is your franchisee clients. Many franchisee clients will come to you and tell you that they have heard how much money they can make from the franchisor. Franchisees, by the way, are allowed to get that information from other franchisees, and the franchisors routinely refer them to their franchisees for them to get that information. And of course, as I said before, item 20 has information concerning the names and addresses and telephone numbers of other franchisees in the system, so a franchisee or prospective franchisee would be well advised to contact those other franchisees in order to gain information about their income potential. From the franchisor, the information is only allowed to be provided if it's in the FDD. So if your client is one who has obtained financial information from a franchisor concerning potential earnings or historic earnings, and it's not in the FDD, the franchisee should be wary of the franchisor. The franchisor is violating New York State and Federal Trade Commission regulations, and as I said, you should be concerned about that. The definition of earnings claims or financial performance information is stated in the regulations of the Attorney General's office relating to the sale of franchises, and should be reviewed. But generally speaking, it's any information that is provided to the franchisee from which they can obtain or derive a calculation of how much revenue, earnings potential, or income they're going to have, whether it's on a monthly, weekly, or yearly basis, whether it's a break-even point, I'm simply telling someone they're going to sell 1,000 hamburgers in the first month of business, and if they know that they sell for $5 a piece, they know how much money they're going to make. That's an earnings representation, a financial performance representation, and it can't be given unless it's in the FDD. I have a client actually who acquired a real estate franchise and was told by the franchisor how much of a particular market he should expect to get as a real estate broker in a particular community, and how much was sold in that community the prior year, and how he'll do 10% of the business in that area in his first year of operation. And he supposedly had an idea of how much income he could earn as a result of that, and that's an earnings claim or financial performance representation. The franchise agreement is obviously a critical document in the relationship between the franchisor and the franchisee. Now, the FDD, or disclosure document, that I've just been describing with 23 items of information is just that. It's the disclosure document. It's not an agreement. The agreement is the franchise agreement, and typically those are relatively lengthy documents that contain all of the rights and obligations and requirements that the franchisee is going to have, and they can be very, very extensive statements of what the obligations of the franchisee are going to be in the operation of the franchise. And they will talk about the fees, which are also stated in the franchise disclosure document, territorial rights that the franchisor is granting, if any, to the franchisee, and as importantly for both the franchisor and the franchisee, any restrictions on those rights or any exceptions to those rights or any reservations by the franchisor as to those rights. So, for example, it's happened in the last 10 years more than before, obviously, is franchisors reserve the right to themselves to sell products via the internet. When the franchisee is going to operate a retail location, the franchisor wants to be very clear that they can sell their products via the internet, or they can sell in kiosks in malls where the franchisee is operating, or whatever it is. There are reservations of rights by the franchisor, and those should be reviewed in some detail, so your clients, if they're franchisees, don't believe that they're acquiring exclusive rights if they're not really acquiring exclusive rights. And if you're a franchisor representative, you should be telling your clients that they should be very clear about what rights they're granting, and they should reserve for themselves the rights that they absolutely intend to keep and those that they might keep in the future or might want in the future. The franchise agreement also contains the term of the agreement. How long are you giving the franchisee the right to operate, and how many times can the franchisee renew that agreement or renew the right to be a franchisee? On renewal, I want to speak about one issue, and this is something that you have to be very knowledgeable about when you advise franchisees or franchisors. Most franchisors do not allow, almost all franchisors, do not allow franchisees to renew the existing agreement. That is, the one they sign today, in 10 years, they're not going to be re-signing that agreement. They're going to be signing what is referred to as the then current form of franchise agreement. That is the agreement that the franchisor is utilizing in 10 years in its franchise system. So this is a 10-year agreement with a change down the line that you know is going to happen. Many franchisors give continuing renewal rights. That is, they allow a franchisee to renew in 10-year increments. Some franchisors don't. Many franchisors don't, I should say. Franchisees would get one agreement initially for 10 years and two 5-year agreements, option agreements in the future, but not have the right to renew after, say, 20 years. The franchise agreement contains restrictions on what a franchisee can do. So, for example, franchisees can't compete in other businesses. If you have a restaurant franchise, you're not going to be able to operate another restaurant anywhere while you're a franchisee, and not within 10 miles and for 2 years after your franchise is over. Those non-compete clauses have to be reviewed very carefully as well, and have to be constructed very carefully if you're representing a franchise. Or the franchise agreement will discuss the termination rights of the franchisee, if any, and the termination rights of the franchisor, which will be extensive for non-payment, for non-compliance with the trademark regulation, for non-compliance with the system standards, any number of things. Those clauses can be pages and pages long. The franchisor's intent here is to protect the franchise system and make sure the franchisee complies not only in payment, but in the operation of its franchise, and particularly in the food industry, to health and safety requirements. It's a critical component of a franchise agreement. Franchise agreements restrict transfer by the franchisee. So you're not able, like a lease does, you're not able to sell your franchise to just anybody. You have to get the franchisor's approval. There are requirements. It may be that the new franchisee that you sell to would execute a new franchise agreement rather than take the rest of your term and assignment of your franchise agreement. There are, as I said, non-compete clauses, and very importantly, there are dispute resolution provisions. And franchisors typically control the method of dispute resolution, whether they require arbitration of disputes or pre-arbitration or pre-litigation mediation, or they allow litigation, but it's only done in a particular state. If you're a New York-based franchisor, typically your franchisor will allow you to litigate only in New York State. And all litigation would take place in federal or state court within the district or county in which the franchisor is located. The arbitration similarly will take place where the franchisor is located. Franchisor has some options here. If it brings an injunction proceeding to stop, for example, the improper use of a trademark, franchisors typically or frequently go to the jurisdiction where the franchisee is located. But the agreement controls the method of dispute resolution, and it should be looked at very carefully, both when you're signing the agreement or creating the agreement if you're the franchisor attorney, as well as when you're about to become involved in litigation. Speaking of which, litigation, I've been doing franchise work for about 20 years, and there are a number of claims and litigation arbitration claims that are brought typically that tend to be the ones that become issues between franchisors and franchisees. And there's a fair amount of litigation, and it can be relatively complex because it involves everything from breach of contract to non-competition to antitrust violations to trademark violations and so on. So there's a lot of different types of litigation involved in franchising that you don't see in most business relationships, and there's a fair body of law on disputes between franchisors and franchisees. Although what's interesting about it is it's not, New York, for example, doesn't have cases on all of these issues that come up. We typically look at rulings in other states on issues that are of importance to a franchise client in, say, New York, because it just so happens that, not every state, notwithstanding the breadth of franchising, not every state has that much litigation on every issue that comes up. From a franchisor perspective, the types of litigation usually involve royalty claims. Franchisee doesn't pay the royalties that are due, or advertising fees that a franchisor typically charges, and they don't get paid. They bring a collection action and maybe a termination of the franchise, a declaratory judgment that the franchise agreement's been terminated. Those claims are very common. Trademark violations. Once you terminate a franchise, and if the franchisee continues to operate, or if the franchise agreement is expired and the franchisee continues to operate under your trademark, there's a lot of trademark litigation in which a franchisor asks a court to issue an injunction prohibiting the franchisee from continuing to operate under that trademark. Non-competition agreements have a substantial amount of litigation because typically, as I said before, franchise agreements provide that franchisees can't operate for a period of, say, 2 years after the termination of the franchise agreement within a geographical area, let's say 5 miles or 10 miles of the former franchise location, or at the former franchise location. So oftentimes you'll find a hamburger restaurant operating under a franchisor's trademark, continuing to operate as a hamburger restaurant but under a new name. May not be a trademark violation because there's no trademark involved, but certainly it's a non-competition issue. And franchisors typically protect their franchise systems by bringing non-competition claims against franchisors based on non-competition agreements. And that litigation can be very, very complex. There are a number of issues, and it depends not only on the state in which the franchisor is located, but the state in which the franchisee is located. Because notwithstanding the fact that a franchise agreement with a New York-based franchisor will utilize New York law, will have a provision that says New York law applies, if the franchisee is located in a state that considers non-competition clauses and agreements to be those that affect public policy, and most do, the state in which the franchisee is located its law will apply to the non-competition claims. So you're well advised to review the law of both your state and the state where the franchisee is located when litigating either on behalf of a franchisor or a franchisee on a non-competition claim.